two people, the President of the Republic of Kenya and his deputy. Now, if that's not interference, I would like to know what interference is. Secondly, I've had a lot of talk about witness threatening and the Kenya government non-cooperation. The Kenya government can only cooperate with the ICC to the extent that its national laws allows it. Understand that in Kenya we are a sovereign state. We have a constitution and we have our own laws. The Attorney General of the Republic of Kenya and the Kenyans and the President and everybody are bound by those laws. It does not matter if the ICC requires Kenya to do a certain thing that is prohibited by national law. By national law and the constitution, they cannot do it. Just 2 weeks ago, the Attorney General went to the ICC and made a presentation where he said his hands were tied. He could not compel witnesses to go to the ICC and testify against the president and the deputy president when the national laws did not allow him to do that. Under the Kenyan constitution, the Kenyan law are supreme to treaty law. And that's a reason why that happened. Now, the other issue that is totally related to that, I would like to bring to your attention that this Kenyan ICC cases has focused unfairly on the prosecution side. And I understand, I'm a human rights lawyer. I totally understand that the victims deserve justice. But we are not going to be according victims justice by going after the wrong people or by administering a flawed justice. In this case, it is my opinion that the ICC has shot itself in the foot. You understand that under the Rome Statute, Article 66, there is a presumption of innocence. They have not honored that. Everything that's going out in the press is that the President of Kenya and his deputy are guilty. I don't speak to that. I have no personal opinion on that. But I think as a human rights lawyer, I believe in the presumption of innocence. Those are some of the hallmarks of a criminal justice system. Presumption of innocence. If you look at the US Constitution and all the great constitutions around the world, we have to pay tribute, homage to that to that principle of presumption of innocence. The other issue is the process, the flawed process that the ICC prosecutors, and let me backtrack. One of the biggest problems that the US, Israel was a member of a Rome Statute for a short time. They withdrew. The reason they withdrew, because they said that the prosecution had too much power. I personally, my personal opinion is exactly that. The prosecution in the ICC case, in the ICC, under the Rome Statute, have too much power. Now, when they were allowed to come into Kenya and investigate the case, you heard the stories about what the investigators did. They colluded with human rights organizations, threatened witnesses, bribed them, coached them to give false testimony. Why do I say that? If you go to a third world country like Kenya and you're dangling money in front of people of no means, poor people hitherto to this investigation had nothing to live on. These people were offered money. If you've been reading the news, you've seen how much money they were offered. They were offered education for their children. They were offered to be taken out of the country to live abroad. And they went for it. And it has turned out to be such a fiasco. I mean, in the magnitude of 60 plus witnesses withdrawing in a single case, that tells you there's a problem with the process. So that's how I look at it, and that's my view. I think this whole process is flawed, and I think it's okay. It's fine. They've been the president and the deputy. They've been accused of committing certain crimes. Just because an accused person is accused of committing a crime does not mean they committed it. That's why when we go to court, we have convictions and acquittals. Why do we have acquittals? Because the court ends up ruling that this person is not guilty because the evidence does not prove that they committed the crime. This could as well end up being the case. Another last point I want to make. The Rome Statute says that the most responsible party should be held accountable. In this case, that was not the case. The names that were forwarded to the ICC were 12 names. They ended up indicting 6 people. What happened to the other 6? We don't know. They didn't explain that there wasn't enough evidence. But in my view, the 2 principals following the 2007-2008 election violence were the most responsible. And to go back to what you asked him about the public perception or what the public feels about the case, initially, I think Kenya wanted to go to the ICC and obtain justice. But within a short time, I think we realized we are not going to get justice from the court. That's why Uhuru Kenyatta and his deputy were elected president by the public, while there were still indictees or there was still accused before the ICC. Because even the African Union, when the Kenya Parliament voted to go to the ICC, they went to it reasonably expecting, and rightly so, that it was going to be an impartial process and that we were going to obtain justice from it. But I think later they realized that that's not the way it was going. And they have every right to withdraw and to register their dissatisfaction with the way things are going. And that's what they've been doing.
Well, thank you, Regina. You covered a lot of points. You've made statements that I believe are not fact-based. And are not supported by people who have intimate knowledge of the issues that you've addressed. But as a trial lawyer, I want to ask you again, the question I asked has to do with the narrow issue of should heads of state be held accountable? In 1997-98, Kenya said absolutely when it had to do with Yugoslavia. Now, the position, I understand it, is it's a different position, that there should be immunity for Kenyatta and others. So the question is, why the shift? I mean, it's just the principle, not the facts. Why has there been a shift in that position? In the United States, those of us who are old enough to remember, we had a president in 1973-74, Richard Nixon, who it was said of that U.S. president by an American Bar Association president that no one is above the law, not even the President of the United States. There's no immunity for the President of the United States. And the fact that he was pardoned by his successor indicated that if there had been no pardon, President Nixon would have been tried, would have been impeached, and that's what the law is in the United States. That's what we're accustomed to in the U.S. You can sue anybody. You can bring to account anyone in this country.
Mr. Greco, can I make a quick intervention?
Yes, please.
Do you believe that that's a plausible argument to the rest of the world, given that the United States engaged in enhanced interrogation and there has been no judicial inquiry in the United States, and the United States does not accept any international investigations of U.S. conduct?
Yeah. Well, David, that's a valid point. The linen in the U.S. is not all clean. We know that. There have been. By that I mean that we know that there are mistakes made that we regret, that I regret deeply. But that's a different issue.
No, but that's
It's the same issue.
Sorry.
No, go ahead.
No, sorry.
No, please.
What I'm saying is that I don't believe that you can make that kind of an excuse on the one hand, and on the other, on the flip side of that coin, exact such a high measure of, just a measure for justice where you are not willing to be touched by the same pole as a nation.
Let me say something.
Yeah.
If I may intervene, I largely agree with Michael's analysis that a lot of arguments raised by my colleague Regina are not credible. But to start with the last point, on the immunity of heads of state, the starting point beyond the Rome Statute and the draft protocol of African Court of Justice and Human Rights, which, by the way, does not also recognize immunity for sitting heads of state, is that the Kenyan Constitution itself, Article 143, subparagraph 4, if you Google it online, does not recognize immunity for the Kenyan head of state in a situation where Kenya, the Kenyan government, is a party to a treaty that does not recognize immunities. That's the first point. Okay. I agree largely with Michael that the arguments of prosecution of whether George Bush and others are not credible, or arguing that you should hold off prosecutions until a head of state is not valid, does not really hold water, because there are institutions that exist to date. I did talk of the African Court of Justice and Human Rights that actually is being discussed and is in the stages of at some point being adopted. But the whole discussions of immunity also is stalling the whole process, because the development now, for me coming from the AU summit just recently, is that the argument being advanced by some states is that following the Assembly of States Parties meeting of November, where the African Union was suggesting an amendment to Article 27 to allow for immunity of heads of state, is that if we want to convince the rest of the world that our heads of state should not be prosecuted for the entirety of their time in power, then we should start by amending our own protocols. Now, you have to understand the implications of amending Article 27 is not that immunity is going to be granted only to Africa. It is immunity for the entirety of the world. That's the other thing. Then I would like to touch on a few things that Regina said that are very inaccurate.
Okay, before you go there, let me just clarify about this immunity thing that you're throwing around. As I said before, I don't speak for the government of Kenya. My personal opinion is that I don't believe that the president should have gotten immunity. My problem is the process. What I'm saying is that I do not believe that the president should be immune, or his deputy. But if subjected to a trial like they are subjected now, it should be impartial, and the process must be credible. I have a problem with the process.
Okay. So, if I may, you just reminded me the point that you made. So, presumption of innocence, you said there is the perception that the suspects in Kenya are presumed to be guilty. That is a flawed perception, and I'll explain to you why. Despite the serious charges that the three accused are facing now, and let me focus on the two, the deputy and the president, they are enjoying all their rights. You will remember very well that Ruto was excused to go and attend to national matters after the Westgate scandal. So they continue to actually be presumed innocent. And remember, most importantly, they are still under voluntary summons to appear. So there is no assumption there that they are guilty. They are still presumed innocent until proven guilty. The other point I would like to touch on, you talked about Article 7 of the Rome Statute, interference administration of justice, and you gave only one side of the story. You'll remember that there's a Kenyan journalist, Walter Baraza, who is under an arrest warrant in the whole entire Kenyan situation for the same crimes, interference with witnesses, intimidation, and bribing them. You talk of the ICC bribing its officials. Where did the ICC get the money? The ICC is having problems with getting money to conduct all these investigations. That is not a correct reflection of these issues. The other point I would like to point out, I spent a lot of my time traveling to Kenya. I was in Kenya in August of 2012, in the run-up to the elections. In my analysis and my interaction with Kenya, what led to the election of the then two suspects was the whole rhetoric that you hear from now and again, that the ICC is a colonial and imperialist institution. I remember very well in August 2012, the mother of the current president did go on national radio and said, the colonialists came after my husband, and now they're coming after my son. Those are sentiments that galvanize support of African peoples when you bring back memories of colonialism, which was a truly very bad event in Africa. This whole issue has been politicized beyond anything. The ICC, you say, is politicized. ICC a lot of people might not like the judicial decisions that it makes, but at the end of the day, we have to remember the ICC is a judicial institution and not a political institution that the AU can tell what to do or not to do. Lastly, Article 93 of the Rome Statute with regards to cooperation, you also cited the Kenyan Constitution. Of course, you rightly pointed out what the Attorney General of Kenya said. My reference point to that is Article 93 of the Rome Statute that talks of states parties cooperating with the ICC, and this is an issue that is before the judges who will ultimately make a decision on that issue.
In all fairness, just may I respond
please,
very briefly?
Please, yes, please.
On the issue of interference of justice, there have been accusations and counter-accusations from both sides, as you know. The prosecution, the ICC prosecution has accused the two accused of interfering with witnesses, and the two accused have also accused the ICC of doing the same. Now, I think we cannot reach a conclusive answer on that. We just have to wait for the decision of the court because there are accusations and counter-accusations. So I'll leave that at that. Now, on the issue of money...
Do you honestly believe that the ICC, the Office of the Prosecutor, would intimidate or bribe witnesses?
No, listen. Listen. It's not the Office of the Prosecutor that did it. We have the Kenya Human Rights Commission, and we heard these other non-governmental organizations in Kenya, the Waki Commission. They are the ones that did the groundwork and all the investigation upon which the ICC relied. If you remember, Kofi Annan was given the Waki Commission report in October 2009, and the envelope containing the names of 12 people. So they went and used that as the background on which to base their investigation. So the people that actually did all this is the Kenya Human Rights Commission, which is an organ of the Kenya government, by the way, and a creation of Kenyan Parliament. And as you know, those that are Kenyans here, if you read the news, you know what the accusations have been and what the news have been in regard to that. And some of these witnesses that have withdrawn have come up with concrete evidence that they were coerced and they were coached and where they were coached and what they were told to say. Now, on the issue of money from the ICC is required under the Rome Statute to protect the witnesses. And part of protecting the witnesses is getting them out of harm's way. If they believe that if these witnesses are going to give, if they gave testimony, especially in the Kenyan case, where the accused are the president and the deputy president, they could be harmed, right? If you read the Barasa case to which you referred, those witnesses under the Baraza's case have produced evidence how they were given a lot of money, up to over 100,000 Kenya shillings, to go to Uganda, to go to Europe. They were settled with their children. Most of these witnesses are not in Kenya. They're in Europe. They're being kept in hotels. They're being paid money to pay for education for their children. They're being given money to establish future businesses. All that is in the news. And the ICC, the prosecution has not denied that part.
Where has this been reported? Because I'd like to read what you've read about this subject.
Michael, just 1 second, please.
Yeah.
We're going to let them finish, and then he's going to call out questions.
We will, yeah.
My last point is this.
I'm saving time for questions from the audience, for sure, yes.
To say that the Kenyan people voted for Uhuru and Ruto based on rhetoric is really underrating the Kenyan people. I think the Kenyan people had a chance to consider the whole situation of the ICC. And are there people that were influenced by the rhetoric? Yes. But are you going to say that everybody and the elections turned out the way they did because of the rhetoric? I don't believe so.
No, please. The rhetoric that I referred to was the quotation from the ambassador of Kenya to the United Nations, the eloquence of those words, the rhetoric, which are belied by the actions that then I followed. So I would never impugn the right of voters to come to their own conclusion when voting in an election. They are free to hear and decide and vote as they wish. So if I misspoke in some way, I wanted to correct that because
but that's fine.
Somewhat, well, anyway, so that's the clarification on that. Well, let me touch on one other subject by asking David to comment on something, to elaborate on something that he said, so that we have, and then we'll come to questions from you all, and it has to do with the peace versus justice dilemma, controversy, because there are those, of course, who believe strongly that if you are insisting on holding people accountable to achieve justice, that may jeopardize or destroy the chances for peace, for reconciliation in a country. That's the debate. Where do you come out on that? But what is the thinking about it? The Rome Statute and the prosecutor, both prosecutors of the ICC, have made it clear. They say their job is to enforce the statute that was agreed to by now 122 nations. And that statute says to the prosecutor, your job is not peace. Your job is to hold accountable those most responsible for the murder and torture and massacre of millions of people. So my job, the prosecutor says, is justice, it's accountability. There are those who will say, well, then you're closing your eyes to the fact that reconciliation and peace are at risk. So David, amplify what you said about this dilemma, and where do you come out on it?
Well, I think you've teed it up very well in terms of it. I think it really depends on whose perspective you're looking at it from. I think from the prosecutor's perspective, it is not their job to try to understand or anticipate what the political ramifications of investigations might be. They're not well suited to do that, and just as you said quite eloquently, that's not their mandate. Their mandate is to investigate and prosecute. But there is, of course, a provision in the Rome Statute which allows for an international organ to take that kind of thing into consideration, and that is Article 16 of the Rome Statute, which allows the UN Security Council to defer an investigation for up to 12 months, renewable, if it feels that an investigation is getting in the way of a peace process or otherwise somehow poses a threat. And Kenya, of course, has gone to the Security Council and asked the Security Council to use its Article 16 powers. It has declined to do so. So I don't think it's the prosecutor's job. I think in any controversial case, you're going to have a lot of rhetoric about what the likely impact of investigations will be. I don't think you can expect the prosecutor to assess that in any systematic way. But more broadly speaking, and here I'm going a little bit beyond my level of expertise, but I think there is a degree of debate in the scholarly literature about the relationship between international prosecutions and reconciliation processes. And I think all I would say is I think it's complicated. And I think the kind of human rights, international justice line that there's no tension here, that they're compatible, and that in fact if you don't have justice you can't have peace, I'm not sure that's right. Based on what I know of these situations. And so I think it's actually quite complicated on the ground. If I could make one broad point about the debate, I find myself in a difficult position because I'm, on the one hand, fairly unsympathetic to the Kenyan government, which, I tend to believe what the Office of the Prosecutor says about interference with witnesses. I tend to believe the Kenyan government is doing what it can to make sure these cases fall apart. So in the micro sense, I'm not very sympathetic to the Kenyan government. In the macro sense, though, I'm quite sympathetic to the idea that we have a very clear double standard when it comes to international justice. And you have certain countries that have opted out of international justice, and you have certain countries that have decided they're going to be part of it. And moreover, I'm also quite sympathetic to the idea that the International Criminal Court takes into account politics when it decides where to investigate. And so I do not think it is coincidental that the ICC has not opened a full investigation in Afghanistan, where it knows the United States would be very hostile to that, NATO would be very hostile to that. I do not think it's coincidental that there was never a full investigation in Georgia when the ICC knows that Russia would probably be quite uncomfortable with that. And it's also abundantly clear that the Security Council referrals to the court are done almost entirely on political grounds rather than on level of humanitarian suffering or humanitarian need. I mean, there's no principled way in which you can say, yes, a referral for Libya, but not one for Syria, or Sri Lanka for that matter, that doesn't involve geopolitics. And so I believe there is a double standard in international justice. I think the difficult question for African countries who point this out is, well, what are you going to do about it? You know, if you believe there's a double standard, either you accept it and you continue to cooperate with an institution that you have pledged your support to through the Rome Statute, or you say we're opting out of this system. And right now, I think many African states are trying to have it both ways. They're trying to say, we want to be part of the system, but, well, we may not cooperate and we're not going to respect arrest warrants, and if Bashir comes to our territory, we won't arrest him, but we're not going to leave the Rome Statute. And I think that's a kind of fundamentally dishonest position. And I think, you know, it may come to a point where they have to make a more clear-cut decision about what their choice is on the ICC.
Okay. Yes, please.
So, I just wanted to point out another article in the Rome Statute. Like David talked of Article 16, but also Article 53 of the Rome Statute, in a situation when the prosecutor of the ICC is conducting investigations in a situation, the prosecutor is supposed to look at both sides and the implications of peace and justice in that situation. It's after that the determination that the prosecutor can recommend to the judges whether to proceed with the case or not. And so there is that clear provision in Rome Statute, Article 53. I would definitely agree with David on the double standards of international justice or the uneven landscape of justice. Like David pointed out, there are members of the Security Council that shield their citizens or shield their allies from prosecutions for whatever reasons, Syria, Russia, Israel, Palestine, and all the situations. Like David mentioned also Georgia. Now, David's question was, what are African countries going to do about this? There's two ways of going about it. In situations where you have concerns about international justice, the Rome Statute clearly states that the ICC is a court of last resort. This is an opportunity for African states to conduct fair and credible prosecutions and investigations at the national level to hold suspects accountable. That's the first step they can take. Secondly, with regards to Security Council, you have rotational membership of the Security Council where African members are also members of the Security Council, part of the 15. That is also an opportunity for them to exert pressure on the Security Council and point out these double standards where they exist.
Okay. Regina, do you want to comment on?
Briefly, I just think from what David said, I think African countries are reluctant about leaving the Rome Statute. They see the intrinsic...
about leaving?
Leaving
opting out. Opting out.
Opting out. There's intrinsic value in being a member of the Rome Statute, but it's not serving them well. So this is a period where the African continent is really grappling with whether to stay or to leave, and looking at the advantages and disadvantages and weighing their options. That's what I think.
Mm-hmm. Okay. Well, we have about 20 minutes left. I'm going to open it up to the floor, and unless there's something that I should know about.
I just wanted just before we get into the question and answer session, which Professor Levano take charge of. As a matter of protocol, we just wanted to acknowledge the Deputy Chief of Mission of the Kenya Embassy, Mr. Lesain. We're happy that you're in the audience. We just saw you and thought we should acknowledge you.
Yes. Please raise your hand so that we can do that. Yes. Okay, so do you want to participate, or
Why don't you go ahead and field questions? And I also want to thank Regina and Jogu for coming on rather short notice after Ambassador Muley was unable to attend,
Yes.
as we previously expected and planned. And we do need to vacate the room at 8 o'clock promptly, so I just want to make sure that people are precise and parsimonious in their wording, please.
Yes.
And please identify yourself. Thank you.
Yes, I want to add my thanks to Regina for pinch-hitting at the last minute and coming in not knowing what to expect, and I hope I wasn't too hard. But I'm a lawyer accustomed in the courtroom to asking questions and following up with questions. So
It's okay.
Good. So so many hands. So let me start with that gentleman, and then we'll work our way this way. Yes.
Toby Catton, I'm a British lawyer, and I was previously on the Kenyatta defence team. My question would be, assuming that the case collapses, which is on the verge of collapse, where is the ICC going to find itself then? Because it hasn't exactly covered itself in glory up until now, and so this would be a disaster for the ICC, PR-wise. So really, where would the ICC go from here?
Where would the ICC go if the case is tried and lost?
If it collapses before
The collapses not because of the withdrawal of Kenya from the ICC, but because of the failure of evidence.
Through
Yes,
lack of evidence
yes.
and through the prosecutor
Right.
not taking the matter.
Yes, what you're-
which is a possibility.
It's a possibility. Well, you're aware that on December 19, 2013, the prosecutor requested of the pretrial chamber a continuance of the trial because, among other things, one witness has refused now to testify, and there's evidence that there was tampering with that witness, threatening so that he is no longer willing to testify, and so he's been taken off the witness list. And there was another witness, similarly, no longer willing to risk, apparently, testifying. So the prosecutor has asked for additional time to address the lack of those two witnesses. There are others out there, and so that decision by the trial chamber, is expected. We don't know when, but it relates to your question, Toby, which is the court may deny the request for continuance of the trial or may grant it. But your question is a valid one. What would happen if the case collapses? Let me posit, and you answer, anyone else on the panel answer it. What if there's a trial and Kenyatta is convicted after a fair trial? What would the consequences be on the peace versus justice issue in the African countries? So we have both possibilities. The collapse before trial, the trial actually takes place because there is evidence and cooperation and so forth. So I look to you two gentlemen because you've both addressed the peace versus justice. What would the impact be in Africa after conviction?
Let me start with Toby's question and I'll come to yours. I think your question basically will be a decision that will be made by the judges after they examine the evidence that has been brought by the prosecution and the defense has done its work. At this point, it's really hard for me to say whether the ICC cases in Kenya would collapse or not, because the prosecution continues to conduct investigations and look for witnesses, new witnesses to basically beef up their case. But also that would depend on the cooperation of the Kenyan citizens who are willing to come up and testify as witnesses in the cases in Kenya. If the trial basically concludes with a conviction in the Kenyan case, this would basically be sending a strong statement in support of justice for victims in Africa who have been demanding for accountability, and also would send a signal that no one is above the law in Africa. This would basically actually beef up Africa's image as a continent that is getting rid of its past with all the conflicts that are taking place. But also the other last thing I wanted to clarify is that there is the misperception that Africa is on trial. I would like to point out very clearly, like Kofi Annan has said in the recent past, it is not Africa that is on trial. It is individuals that are alleged to have committed crimes in Africa that are on trial.
Okay, next question. Let me go to the other side of the room. This gentleman, and then we'll go back and forth during the remaining time. Yes.
My name is Patrick there, and let me just start by saying that there has to be some absolute presumption of innocence until they're found guilty, the two principles. And I think on the other side also, we cannot really brush a lot of this newspaper readings and whatnot reports, because I don't know at what point it becomes a street word that becomes a newspaper reading, and they all become a mixed ball. So unless you have very, evidence, I don't think some of the things that have been said should really have been said. I'm not a lawyer, but I also know that there is what, in terms of in law or in prosecution, there's also protection of witnesses, which essentially takes these witnesses out of their own normal life and puts them in a different format where they have to be supported some way or another. Now, when you go back into even what is happening right now in Kenya and the historic Kenya system, we know that right now in Parliament in Kenya, there are laws that are really regressive, both in the communication side, the media side, and totally trying to stifle the human rights movements and the civil society. So really, there's a lot of things that can be brushed that I really don't think that can be brought in here. But one thing that I would ask you is whether, and this has been mentioned several times, the perception. When something is said over and over and over, if you call the thief, you're a village thief. Even if you're 20 miles away and something gets stolen, you're still the village thief. The perception. And I think the perception that the ICC has given is a level of incompetence, if I may say so. Because, again, the perception of the people is this big Goliath, supported by the US, supported by the West, whether true or not, but his perception. And they're coming down on this small country, on this poor people, and they want to jail our leaders. And there's, I think, from my perspective, the readings and whatnot, there's a level of maybe incompetence, because the perception of the people, why do you have to keep postponing things? If you don't have enough evidence, then why don't you just say you don't have enough evidence and let the people go?
Thank you.
So how do you address that?
Mm-hmm. Yes?
I think that ties to the question that was previously asked, and he answered very ably. But I would say that if the cases before the ICC collapsed, or there was a successful prosecution of the cases, either way, the ICC's image is dented, because of these cases, the flaws and the weaknesses and all the problems of the ICCs have been exposed. And what the ICC will need to do is to address these problems and redeem itself. That's my opinion.
Mm-hmm.
The perception out there is that the ICC has all these problems. They've been exposed. They were there, but because of this case, they have been exposed, however way it turns out.
I really don't know whether you want to say exposed, because exposure means that you have evidence that they've done this. I think it's just a matter of word in the street that the perception that they've done that. So I don't know whether you want
perception
to
is created by
Yes.
what people have been fed with.
Okay, and there's been a lot of force feeding going on in the last couple of years by some. Anyway, back of the room,
I
yes.
just want to make a minor point, because I don't want to take away the KPLAB, I don't want to take away from other questions. But to the gentleman's comment, which is an incredibly good one, what needs to be understood, though, unlike national jurisdictions that have power over police to go do these things, ICC works on cooperation. So if their cases are falling apart, it's because cooperation isn't there from the states. isn't there from the states to help facilitate summons, requests for evidence and such. So when we hear the fact about incompetence, I understand that that's a perception. But in reality, ICC doesn't have a police force to go out and do these things. So it has to rely on the state. So that's just one minor point I wanted to correct.
Mm-hmm. Right. Okay. This gentleman, yes.
Yeah. Rob Lauren, I'm a master's student in SIS, studying transitional justice. I have one question for Professor Bosco and one question for Ms. Njogu. Professor Bosco, in Rough Justice, you talk about the 4 anticipated or potential state behaviors that we'll see toward the ICC. And Ms. Njogu mentioned one is that European money has influenced the prosecutor. So the question for you is, to what extent has Fadi Bensouda's or the Office of the Prosecutor's independence been compromised? And in what way? And for Ms. Njogu, I think we've talked a lot about the balance between peace and justice. What reconciliation techniques, what peace is being sought in Kenya right now and how would an ICC prosecution or the continuation thereof impact or negatively affect those reconciliation efforts?
Okay. There's so many people who want to ask questions, and for you to ask 2 at once, choose which one you want answered. And
the second one, sure.
The second one, okay.
Right. I think your question was about the money that the European. Okay. Understand that, as I said, they provide 60% of the funding for the ICC, so they fund the operations of the ICC. I mean, a bulk of the operations of the ICC, and they also help pick the top members of staff of the ICC. Actually, they influence a lot who the top prosecutors and the judges are, and that's where I see the influence. Now, on the issue of peace and justice, actually in Kenya, after the 2007 and 2008 violence, there were many steps that were put in place to address the issue of peace. But I will quote one of the most highly quoted Kenyan political pundits, Mr. Mutahi Ngunyi. This is exactly what he said. He said that immediately after the violence, Kenya lost about 1,300 people died due to the actual violence. But the ICC cases will actually cause more than 10,000 deaths. I believe it. We have already started seeing it. People disappearing, people being killed, and I'm not blaming either side. I think some of the blame goes to the state and to the handlers of the 2 accused that are intimidating witnesses and whatever is going on. So it's imperative that if Kenya decides that they want to pursue the cause of peace and justice, and of course, because Kenya has already subjected itself to the jurisdiction of the court, withdrawing at this point is next to impossible because the process has already begun. But it can be done simultaneously, in my opinion. We can go ahead with the trial, but we can also pursue steps towards achieving lasting peace.
Okay. We have about 7 minutes, but did you want to say something?
Very
Go
quickly
ahead.
on the
Sure,
perception issue. I just wanted to point out, of course, the ICC has a whole section, public information and documentation section, that exclusively deals with public information and outreach that is working on that. But also the African Union level, they've had 2 technical seminars to try to address the perception issue with the legal advisors. Hopefully they're going to have a 3rd one to address that issue. But perception also could be flawed. I'll give you an example. I worked on the ICC case in Uganda. Now, some of the perceptions from the communities concerned issues of prisoner conditions. For example, there was a perception that if you prosecute the LRA leaders and you take them to The Hague or a host country, they're going to enjoy standards of a 5-star hotel. So you should instead imprison them in Uganda, where the conditions are very difficult. Now, that perception is flawed in the sense that the court has certain standards for whoever is convicted. They have certain standards, okay? That's the same thing with the whole perception of the targeting Africa, which is flawed for a number of reasons that a number of you have already heard. So perception could be flawed, but it's a work in progress that the ICC should continue to address with sufficient funding that states parties should provide. Regina, I like your intervention, but I just wanted to correct one thing. I do know that for a fact Japan contributes over 20-something%, so I'm not very sure about the 60% you're talking about that comes from Europe. And also, in terms of the selection of the senior government officials of the ICC, you must note that the AU has a whole committee on selections, where every time that a position comes up in an international organization that the AU wants to have influence, they do nominate candidates. The point is 2011, the AU nominated the prosecutor. They've continued to nominate African judges to senior positions at the ICC and different organizations. So I just wanted to put that on the record.
Small fraction.
And the prosecutor, Fatou Bensouda, is from what country?
The Gambia.
But
Yes.
fronted by the EU anyway.
No, the AU.
EU.
Yes, you've had your hand
Very
up.
quick question.
Okay.
This for Professor Bosco.
Okay, quick question.
Now, we remember Johnny Carson with choices have consequences.
Comment.
And we know that President Kenyatta is coming to Washington in August. Are there still consequences?
Is that confirmed that he's coming to Washington?
He's among the African leaders who've been
Okay.
invited to come to Washington.
I mean, it's difficult. It's a difficult choice for the U.S. because, and you know, the British, David Cameron, the Prime Minister, met with Kenyatta. But it's difficult because Kenyatta is not in the same position as Bashir. Bashir is subject of an arrest warrant. Kenyatta is subject of a summons, and he's formally, again, cooperating with the court.
But they're also saying they were not dealing
Yeah, they did say.
He's presumed innocent. He's just an accused.
Yeah. So,
Yeah, I don't know what's going to happen with that.
yeah,
Is the short answer.
I was really pointing to you, so if you have a quick question,
Yes,
let's...
I do. Isn't Scott Kearney, AU, SIS, foreign policy alum at Masters? Okay. Isn't a lot of the controversy, whether it's about the ICC in particular or international jurisprudence in general, really because it's victor's justice? It certainly was in Yugoslavia. Efraim Rios-Montt, the Hitler of Guatemala, got off on technicality. No Contras are in the dock anywhere. And certainly no Israelis or Americans, so that would be taboo, unthinkable. Isn't that what all the promotion's about? It's just victor's justice? Hell, it was in World War II also.
Mm-hmm. So, anyone want to comment on that?
Well,
Didn't get it.
My comment to that would be an argument that you advanced before the ICTY, ICTR. As you know, that the ICC was set up to be able to investigate and prosecute cases in ongoing conflicts. So you need to point out to me which of those cases, the 8 of them, are victor's justice. But I also mentioned that in some of the situations you have governments recommending some of their opponents to the ICC.
Right.
I've been on this side of the room. I have to go to the other, or maybe in the center. Let's start here and then to the other side. Yes.
Yeah, a quick question. I was just wondering, do you guys think it was a mistake for the prosecution to be housed in the same building with the other side, with the judges of the ICC, and to Regina Njogu? I want you to explain why you say that the Kenyan election was kind of like a referendum. Kenyans decided that they don't want this ICC process, when we as Kenyans clearly know that it was a tribal vote almost to the man. You know, like in America we have red and blue states. In Kenya we had dark red and dark blue states. So I just wonder why you're bringing that up, because we clearly know it was a tribal election, had nothing to do with the ICC. Whichever side, whoever was accused, it would have gone the same way.
Okay. So your first question, repeat it please, so that we'll see who
Prosecution being housed in the same building with the judges of the ICC appears like they're all on the same side working together. Do you think that was a bad decision when the Rome Statute was created? Should they have been separated, maybe taken to a different country, and the judges placed in a different country in Europe, just to give the perception of fairness? Because a lot of people who don't understand the ICC feel like maybe Bensouda and Judge Osuji go eat lunch together.
Yeah, no, I don't think it's a problem. I mean, again, maybe there's a perception of a problem, but I know that there's absolute division. In fact, there's tension, which is a healthy tension, between the office of the prosecutor and the chambers, and even the registrar. Those three, under the Rome Statute, each has independence, and boy, they exercise that independence. So on the outside, it may appear, gee, you know, maybe they have lunch together and they chat. On the inside, they go their separate ways, number one. Number two, the tension that is healthy that exists is in the Rome Statute, because the prosecutor, even when she wants to initiate an investigation, cannot do so until the judges approve it at the pretrial chamber level. So no, I don't think it's an issue. There are many other things I could point out in the Rome Statute that provide checks and balances, checks on the power of the prosecutor. I mean, I've heard several people say, the prosecutor has too much power, and untrue. I teach this course on international criminal justice in China, and we go through with the students comma by comma of the statute, and we see where the prosecutor does not have power, or if it has authority, it can be overridden by the judges. So, but that's a whole nother program and we're close now. In fact, we're at the bewitching hour. Is there one really compelling question? Raise your hand if you. If it's
it is compelling.
Okay, where am I? In this side of the room. Okay, you get the last question.
My question is this. I'm Catherine Wanjiko Mitchum. I'm a Kenyan living in Washington for about 25 years now. Here's my question. Is it possible, and is it within, sort of like for Uhuru's or the accused, their lawyers, can Ocampo be subpoenaed and brought to the court, put to the stand, and asked to just really expand on his recent comments that he gave to the media in Amsterdam? Because if it's true that he was being pressured, felt a lot of pressure from ambassadors or Western diplomats that he could not mention on camera, but yet those conversations did take place. Can he be compelled so that we can all, well, not we, but so that this justice process can see the full picture? That's my question.
Well, so the question is compulsion. Can he be compelled? He voluntarily could speak, of course, and I have a feeling of what he would say, but that's my own feeling. But the question is, can he be subpoenaed? So, gentlemen, or Regina, do you want to answer?
I'm imagining there's a privilege probably that would apply in that situation. I don't think the prosecutor's office would be required to disclose their internal deliberations, but that's my hunch without it being necessarily based on statute.
I think Kenyatta's lawyers have already indicated that they're going to subpoena him. That, of course, will be decided by the court whether it will be within the rules to do so.
Mm-hmm. Stephen, do you have a view?
I have no view. I haven't read his comments, unfortunately. I was traveling, so I have no view and haven't looked at the Rome Statute to try to find out if there's that provision.
Yeah.
Me neither. So I couldn't tell you either way. But
yes, in the back.
I just wanted for the benefit of everyone knowing that quote, because I thought it was a very interesting comment, and so I looked it up.
What quote?
This is the quote that she was referring to, and I just wanted to read it out. There were some diplomats asking me to do something more to prevent Kenyatta or Ruto to run in elections, and I said, it's not my job. Judges in Kenya should do that, and if they authorize them to run, people will vote. And if people vote for them, we have nothing to say. My perception of that comment is that isn't some sort of undue pressure on Ocampo to pursue these cases.
it is.
If anything, it's a comment saying that it's outside of his purview.
Right.
So I just looked it up.
Well, thanks for that. And what it says is that we have to be very careful in making comments, all of us, that are perhaps not all four corners correct. So.
All right, I want to thank
I want
to thank the American Bar Association. It's been great working with them and pulling together this event, and also working with the Student Africa Initiative that really helped promote this event. And there's also a new diaspora organization, East Africa Washington Program, that helped come up with the idea for this event. And it's been great working with them. My closing comment is that Mwalimu Julius Nyerere, in his commentary on democracy, what is democracy? He was the first president of Tanzania. He said, you have to be able to respect dissenting views, and I just want to say that I'm really impressed by the discourse and the decorum of debate in this room tonight, so this has really been a great education for all of us.
Thank you for those comments. I want to ask you to join me in thanking our panelists heartily for their participation. And I also ask you to give a round of applause to American University for making this program possible. Thank you and good night. Yes, absolutely.
That was interesting.
Thank you very much.
Thank you. Do you have a card?
It's healthy, isn't it? I don't know, but it's healthy, don't you think?
Of course it is.
Which is the one I really wanted to ask. What I wanted to know was, when we go back to like maybe 2000,
So, well, I hope
I wasn't actually established that I have a master's in Kenya, but they wanted a militaristic approach to Kenya refused. Shortly thereafter,
You mean the United States?
shortly thereafter, Kenyatta, as Minister of Finance, provided
My organization, which was observed election, my nephew was the one among those who were here, and observed election 2013.